Hello, everyone. Welcome to today's book launch. I'm Sean Rehag. I'm the director of York University Center for Refugee Studies. I'm also a professor at Osgoode Hall Law School. So I'm one of Professor Okafor's colleagues. I'm delighted to welcome you here today to this book launch for Professor Okafor's latest book, Refugee Law After 9/11. As I'm sure most of you know, Professor Okafor is the York Research Chair in International and Transnational Legal Studies at York University. He's a full professor of law at Osgoode Hall Law School. He's also the UN Independent Expert on Human Rights and International Solidarity and a former chairperson of the UN Human Rights Council Advisory Committee. The book that he is going to speak to us about today was released at the height of the first wave of the pandemic, which is why we're doing a launch today, several months later. But I'm very glad that CRS has been able to put together this launch. I'm delighted that Obi is here to speak about his book today. What we're going to be doing this afternoon is that Obi is going to be speaking for about 30 to 40 minutes. He's then asked me to say a few words about the book, which I will do, and then we'll have quite a bit of time for questions and answers after that. So welcome again, everyone, and Obi, over to you.
Sorry, I was on mute. I want to begin by thanking all of you for, as it were, attending the lunch in a manner of speaking. Good to see all of you again in a manner of speaking, even those that have the videos off, understandably. Don't worry, Sarah, you can have it up. It doesn't matter, really. So I know everyone is busy and I really appreciate it. I just wanted to say that. Of course, as my colleague Sean has said, the book came out a bit earlier and we just got around to doing this. So thanks to everyone. Thanks for Sean, Michelle, and the Center for Refugee Studies for organizing and actually prompting me, reminding me. Huge thanks to all who helped make this possible, the book, especially my family, my many students and RAs. I think there were like 13 RAs. The book's been long making. Osgoode and York, the Canada US Fulbright program, who funded the research for the US side of the research down there. Where I was housed at the Center for Human Rights and Justice at the MIT. Its director, Professor Balakrishna Rajagopal, a great twiller. The anonymous reviewers, especially the infamous or famous reviewer number 2, eminent scholars whose endorsements appear on the face of the book, literally. My publishers and everyone, really, thank you. So I'm gonna provide what I call a long insight into what the book is about. Like I was just telling Sean, I could speak on and on for about the book forever. You know, if you spend at least 17 years working on something, you know, you sort of know all the nitty-gritties, but I wouldn't do that even if I wanted to. I couldn't in the time that I have, but I'll see how much of a detail that I can provide. All right. So where I want to begin is with what at the time I started was the conventional wisdom, not really articulated initially by me, articulated by quite a few people, but notably Reg Whittaker, that the tragic terrorist attacks on 9/11 changed everything, not just refugee law, had altered the world forever. As a 12 scholar, third world approach to international law, this conventional wisdom immediately struck me as odd, because from where I sat, the history tends to repeat. History tends to fade into the next phase. There's hardly ever rupture, right? So, but according to the conventional wisdom, not shared by all, of course, those attacks triggered sociopolitical and legal rupture, a sharp departure from socio-legal past, whatever that past was. So I began to ask, to what extent, and that's the main key word of this book, the extent to which it is true, right? Given the lessons that we've learned from what, again, Whittaker describes as earlier periods of panic, right? And is a cyclical process that swings along, if you like, the security/humanitarian continuum, right? Which is how I like to think about things, as continuums, continuities, discontinuities all at once. So what are we to make, or what were we to make of these post 9/11 developments? And perhaps continue to make of them even post the publication of the book. So to be sure, as all of most of us would agree, and as Whittaker also pointed out, 9/11, of course, did levy some important, significant changes, right? It precipitated a renewed war on terror. There was a war on terror before that, of course, but a renewed war on terror, the overthrow of the so-called Taliban regime in Afghanistan, and a step up in US interventionism. Not that US interventionism began the day after 9/11, it's been with us for a very long time. Interventionism in other countries. It also led to, if you like, the augmentation of two things. One, a reconfiguration of government agendas and priorities in the two countries under study, Canada and the US. Also an acceleration of ongoing trends, right? And then as well, it led, of course, to famously or infamously to the invasion of Iraq, albeit on a false pretext. And then, of course, renewed and even augmented interest in border migration control, control being the key word here. Yet, we must keep in mind, even as we recognize that it did levy some important changes, as I said, that there's always a danger of exaggeration, right? Scholars needed to keep that in mind, and I kept that in mind. There's a danger of exaggerating the extent, one, and the import of any alterations, if there were any. So against this background, the question, or the overarching question that I asked was whether the attacks and the heightened security vigil, if you like, or sense of security vulnerability that was fostered in the result following the attacks. And I had a sort of bracket there, in the West, or to what extent everywhere in the world. But to what extent did they really change everything within this specific field or area, if you like, refugee law policy practice? What are we more precisely, the more granular way to make of the developments, legal and so on, that occurred post 9/11? Because they were developments. And so, I set out to find out much more exactly the extent, if at all, to which 9/11 triggered changes in refugee law in Canada and the US, and then to compare them to each other, right? And just to see. And my comparative framework was around two, if you like, two loci. So the first, or two locations. The first was, what I call security relativism, right? We often in human rights talk about cultural relativism, but in this case, I was talking about security relativism, the notion that sort of the security of the nation, right, of the country, of the people required trumping of certain rights or all rights, or something like that. And the second one was around, if you like, the sense of national identity of those two countries, what the peoples of those countries tended to think of themselves, or if you like, national self-image. So that sort of the comparative frame that I adopted. So the critical task, I think there was already a sense out there that it didn't change everything, but the more critical task was to map in as granular a way as possible and explain as clearly as possible the precise extent of the alterations and statuses, the continuities and discontinuities, right, that happen. To what extent was there change, significant change, and to what extent was there significant stasis, continuity. So that was what the challenge was for me in working on this book, in researching and writing it. And of course, to what extent, clearly, can the alterations be attributed to 9/11, right? So the data, if you like, or evidence that I examined was between 9/11, September 11, 2001, and the end of 2017. Okay, so just broadly, the questions that I tried to study and maybe provide answers to were as follows, right? More specifically, the more specific questions were, so what changes, if at all, were made after? So after is the first keyword, and then in addition, because of 9/11, right? And were any changes even made at all? And how do they compare to the pre-9/11 situation? In other words, even if there was change, was the departure all that significant enough, right? Was that all that significant to us? And then, how more precisely does the situation in the country that was not directly attacked, Canada, compare or measure up to the corresponding situation in the US, the country that was hit directly by those attacks, right? Was it worse in the country that was attacked, or was it was the reaction better, or were they similar, right? And what logics, if you can call them that, were behind the changes or the alterations that occurred that were observable? What were the reasons for any observed differences in the two countries, if any? And then, of course, to what extent the reactions in either country betray either a praxis of security relativism, and also what logical inferences can be drawn from the evidence in relation to the stability or even the coherence of the dominant national self-images of Canada on the one hand and the US, right? How do they also, first of all, match up to how does what I see match up to the Canada's self-image of itself, and how does the evidence, what does it tell us about the US dominant self-image, and how do they compare to each other? In other words, are Canadians really more humanitarian in this one regard than the US people, to put it loosely? So, I wanted to offer really what was the first deeply granular systematic study of these questions. But one caveat, I did not look at every possible aspect of refugee law. Couldn't in the time that I had. I would have spent another 17 years. So I looked at deportations to torture, detentions, terrorism-related inadmissibility, not even the full range of security inadmissibility, and then the safe third country regime, which continues to be in the news, right? So methodologically, it was mainly a desk study of the academic work, the legislation, the records of legislative debates, records of legislative hearings, case law reports, and so on. Other reports, other sort of reports produced by people who had done primary work. For example, a lot of migration institutes in the US and also in Canada, supplemented by other kinds of data I could get my hands on. Now, in terms of my overarching argument, the book develops and specifies in a much more granular way than was done before it the somewhat counterintuitive argument that although 9/11 was consequential, certainly, they hardly changed everything with regard to the character and orientation of Canadian and US refugee law. In far more respects than not, the pre-9/11 versions of these two regimes, if you like, these two bodies of law, Canadian refugee law and US refugee law, looked much like their post-9/11 versions. The pre-9/11 versions looked pretty much like their post-9/11 versions, only more so. So in far more respects than not, refugee law post-9/11 was refugee law pre-9/11 only 2.0. It's like those Microsoft, programs, right? 2.0. And this is what, from sort of watching my kids for 20-something years, I call the Barristan Bears argument, right? The Barristan Bears, that cartoon, they say we're just like humans, only more so, right? So that was my Barristan Bears argument. So the point here is that in both countries under study here, things were already so bad before 9/11 in refugee law that there was significantly less room than many have supposed for them to get all that much worse. That in fact, the years 1995 to 1997 were at the very least as consequential for the constriction of the rights of refugees in North America and Canada and the US specifically through legal texts and measures as the year 2001. And sometimes even much more consequential, right, than 2001. So the caveat here I must enter is that I want to emphasize that I'm not arguing at all that nothing changed for refugee law after 9/11, because sometimes I've been read to say that it changed, but not nearly as significantly as we would expect, because things were already quite bad. If you cast your mind back to 1995 to 97, you think of the first World Trade Center bombing. You think about September 11, you think of the second World Trade Center bombing, and that can maybe allow us to visualize what I'm talking about. So, so while there were significant differences in the post-9/11 treatment of refugees in Canada by the law in Canada and the US, and in some regards, the US was worse in certain respects, especially in terms of the scale, right, of its responses. For the most part, refugee laws in the two jurisdictions, again, another point, reacted in a strikingly similar way. This is what I argue in the book. Very strikingly similar, which was intriguing, given Canada's dominant national self-image as a much more humanitarian place, which in many respects is coherent, but also which is troubled, in my view, by my findings. So, and it becomes even much more troubled when we look at scale, and we kind of, look at it more carefully. So the greater scale, say the roundups and detentions of Muslims in the US, right? Let's take that issue of scale. So the greater scale of the responses in the US is interesting, if somewhat understandable, although never excusable, if you look at the fact that, unlike the US, Canada was not directly attacked on that day, right? And also, given that the US has a vastly larger population of immigrants and a vastly larger population of Muslims, 3.5 billion Muslims last time I checked, Canada, 1 million Muslims, 7 or 8 million immigrants. Okay, so if you actually look at this proportion question, it reduces the import of the difference in the scale. It doesn't eliminate it, and I have to make that point. It just reduces its import. Now, so these points, both separately, individually and collectively, then raise the questions around in both countries, what we see is security relativism, but not a security relativism that exploded like a sudden volcanic eruption after 9/11 on September 12, 2001, but a security relativism that has been there for a very long time, right? And I think the refugee law scholars here would recognize that. And also, what the data tells us is, or rather, the data then leads us to also question or trouble the cogency, the coherence, integrity of the dominant national self-images of Canadians and Americans. For the Americans, America is the shining city on the hill, the land of immigrants, the kind of dominant self-image. We have to bracket the Trump years that sort of significantly troubled that. But generally, over the long durée, that is the story, right? In the US, the evidence I found troubled that in their treatment, their roundups of Muslims, the way they tortured and brutalized them, and so on, deported them to knowingly to torture, and the way in which the legal regime is constructed. For the Canadians, is two things: a humanitarian country on its own, but always better than the US to a large extent. I did not find that Canadians were not better. I found that they were less better than Canadians think. That's, I think, how to summarize it. And so one question, for example, that could get us thinking is, what would have happened, given what I found, if airplanes had hit tall buildings, say in Canada, God forbid, and hundreds of people, not even thousands, had died? Would Canada have reacted all that differently from the US, even in terms of relative scale? Would Canada have thereafter treated our refugees better than the US did after 9/11, given what we know about the state of Canadian refugee law and national security law pre-9/11 and post 9/11? Would it matter, and to what extent, if we had a particular kind of government? Conservative, liberal, new democratic, right? So these are the questions that are entailed. Now, Sean, how many more minutes do I have? Because that would allow me to make a decision as to how granular I can get. So what I just did was provide the broad overview, but yes, Sean. Yeah.
Another 10 to 15 minutes, maybe?
Okay, maybe I can just give a couple of illustrations in 10 to 15 minutes of, because I've just given you the lay of the land, right? I can give a little more granular, I can get a bit more granular in the time that I have. Okay, so, so just to illustrate, and I can't even go through the entire discussion, right, with one of the topics, right, or aspects of refugee law that I examined in a close way, and just to give you maybe a couple of examples of this similarity and difference between the two regimes and what was going on in each of the regimes. Let's look at deportations to torture, right? Let's look at the legal regimes in the two countries. So one indicator, though of course not the main thing I relied on, of how similar the two regimes, Canada's law and in this area, law and practice, and the US, is that in 11 of 15 key identifiable aspects of the law relating to deportation of refugees and other non-nationals to torture, 11 of 15 areas, Canada's law was either similar or worse than that of the US. Okay, that's one a kind of numeric indicator metric. Doesn't tell even 10% of the story, but just an interesting thing. Quickly, perhaps similarities, right? In Canada's regime or refugee law, with regard to deportations to torture, I found we're about the same as the corresponding US regime when it came to mapping really frontal assaults, not subtle assaults, but frontal assaults by courts, public officials, and politicians, and some in the public against the absolute bar to deportations to torture, meaning respecting the absolute bar to such deportations imposed by the Convention Against Torture, right? But what I found was that these frontal assaults began way before 9/11, right? In many US congressional bills, I can go on and on. Although, of course, there were counterparts. Edward Mackey, who is now a senator, his bill seeking to even prohibit it with greater force and so on. But you see quite a robust attempt to frontally in broad daylight carve out exceptions or denude this absolute bar and render it non-absolute in the US and in Canada, right? The refugee lawyers here will be familiar with the entire CRS case. The fact that the federal court in that case and the Federal Court of Appeal would have ordered CRS's deportation to torture, should make us think. And the fact that the Supreme Court left this undefined loophole at the end of the day, even though not ordering his deportation to torture, but left this loophole, should also concern us. The culpability of Canadian intelligence officers in all kinds of renditions, Mahara and all these cases, should also concern us in terms of frontal assaults on the anti-deportation to torture regime in Canada. And so another quick point is definitional loopholes. Okay, so I just talked about frontal assaults, but what about loopholes, subtle, more hidden, more backgrounded, that allows these states to actually deport people to torture without saying so, without it being clear that that's what's happening, to escape the stricture of the Convention Against Torture. So one technology that states adopt is the definition of torture itself. So of course, if it's not torture, then you're not deporting them to torture, right? So the first is, again, refugee lawyers know this, the definition of a public official, relating to the meaning of public official, because of course, the convention bars torture by public officials, more or less. And that's the kind of torture that in general makes some a refugee or asylum seeker eligible for protection from being deported to torture, right? So in the US, the tendency, to quote one legislator, is to have a, quote, less cramped view of what torture is and is not, right? So that can tell you everything you want to know, using that, sort of whittling down as much as possible that definition of who is there. So even in some cases in the US, even police officers were held not to be, of course, in the country where the person was tortured, were held not to be public officials within the meaning of the Convention Against Torture. The Canadian position on this has not been all that different, just to leave it like that. With regard to the definitional question of whether there was acquiescence of that public official, of any public official, again, some lower courts have ratified, in the US, ratified that country's adoption of the narrower standard, not the standard of the Convention Against Torture, but the narrower standard of willful acceptance, not acquiescence, but willful acceptance of torture by the public official, rather than an awareness that it was happening and acquiescing, but they have to accept it, which is harder to show. Some U.S. Courts of Appeal circuits, as you know, they have circuits there. The Second, Third, Ninth Circuit have rejected this dumbing down of the definition by lower courts, but some have not ruled on it and have not accepted. And then, again, the Canadian position is not all that different. The two regimes are also very similar with regard to complicity in renditions to torture. I've mentioned Mahara and so on. They work, if you like, hand in hand to perpetrate those renditions. Deportations to failed states, quote and unquote, and I use that term rather with trepidation. But anyway, this is what it's sort of said. So put that in inverted commas, such as Somalia, for instance, where even US and Canadian officers will not themselves go. But both countries are prepared under certain circumstances, I won't get into the details, to deport people to such places where they themselves deem unsafe for their officers. Now, of course, in Canada, there is Section 230 of the Immigration and Refugee Protection Act. There's discretion in the minister to bar removals, but they have never barred removals to every part of Somalia, only certain parts of Somalia. So here again, similar position in the two countries, similar position before and after 9/11. And I have a lot more to say. Maybe I should just quickly end with this couple of points. In the two jurisdictions, the courts show a very high degree of deference to decisions of immigration officers. I mean, we can discuss that if people want, but how that is so. But it is, even in the words of the courts, extraordinary high level of deference. That's a language at least the US courts use when describing the level of deference that ought to be shown to the decision of immigration officials. In Canada, despite all the an expert on admin law here, all the bobbing and weaving and undulating, elimination of patent unreasonableness and all that, it ends up being the same. That a very high level of deference is, in fact, it tends to be shown. So the bottom line here is that in the two countries, the decisions of immigration officials, even on deportations to torture, are hard to set aside. Not that they can have never been set aside, but are very hard to set aside. And this did not begin with 9/11. similar gatekeeping culture within their immigration bureaucracies, similar practices of interdiction, for instance. Yeah, I think I'll leave it at that. I was gonna say maybe quickly mention because we're Canadian, so we can have a victory lap. The couple of instances where the Canadian position is better on deportations to torture. In terms of the definition of the meaning of mental torture, right? Mental torture. The US law requires that the person alleging mental torture or that they will suffer mental torture if they were to be deported should show that it will be prolonged, emphasis on prolonged mental harm. Canada doesn't require this, right? So the Canadian position is better in this regard, but there's no significant change in any other country before in this aspect before after 9/11. The standard of proof required in a claim against deportation to torture by the person, by the refugee asylum seeker, is higher in effect in the US. The Convention Against Torture uses the language that the person must show substantial grounds for believing, or that there must be substantial grounds for believing that the person will suffer torture when they are deported to their country of origin. That's the language of the convention. But the US Supreme Court and US law and practice tends to use a much higher standard, or require a much more higher standard of proof, which is that the person will be more likely than not, 50 plus 1%, to be tortured. That's a higher standard than showing substantial grounds for believing. There can be substantial grounds for believing that a person will be tortured without it amounting to a likelihood, or more likely than not. Canada uses the CAT standard, the Convention Against Torture. So Canada is better in that regard. And then lastly, I think Canada is also better with regard to expedited removals of people found near the border. The US would subject you to a harsher regime. Canada does not. And then the scale, as I've said, even when you plug in the proportional numbers of, say, Muslims who were being focused on post 9/11 mostly, the scale of the US response is still more disproportionate than the Canadian one. And Canada is also better in the sense that it would not require, that it is much more skeptical of the use of diplomatic assurances. In other words, a state that's known to torture assuring Canada that it would not torture. Torture, of course, occurs in private. So the idea that a state would say we will not torture someone and a country would believe that is ridiculous. But Canada is a lot more skeptical of diplomatic assurances than the US. The US simply says, oh, yeah, Saudi Arabia or whatever, not to single them out. Diplomatic assurances, yes, deport them. They've assured us that the person will be tortured. Of course, the person will be tortured. Torture doesn't happen in the public square. All right, thank you so much. I could say go on and on, but I'll leave it at that for now. Thank you.
Thank you. Thank you so much, Obi, for your presentation, and thank you so much for this this book. I read the book in kind of mid to late summer, I guess late July, early August. And while I was reading the book, I was thinking a lot about continuities and disjunctions in immigration law and in refugee law. And I was thinking about that partly because I was reading your wonderful book that does this great job at meticulously going through the evidence of precisely what changed and what didn't change. in a few specific areas of refugee law. I found that argument to be really persuasive, the argument that there are more continuities than there are disjunctions. So it's just partly, it was your book that was making me think about this, but it was partly also the period when I was reading the book, when I was thinking about COVID as a disruptor, that countries around the world rapidly changed parts of immigration law practice, closing down borders to refugees. So I was thinking about, are we likely to see 17 years from now someone writing a book about claims about overblown claims potentially about how everything changed as a result of COVID. At the same time, we were in the middle of the US election. And I was thinking the same thing about Trump, about the Trump administration in the United States, and whether a decade from now we can expect books that push back on the idea that there were really massive changes under the Trump administration, and kind of tracing out many of the continuities in immigration and refugee law pre and post Trump. And so one of the lessons that I took away from your book is just to be thoughtful about and critical, I think, of claims about moments when everything appears to have changed, and to insist on, let's pay more attention to the granular details, because that's really where we'll see what has changed and what hasn't. So thank you for that part of the book that I found really helpful. The other part of the book that I found really interesting was the comparative element, the suggestion that differences between Canada and the United States on several areas of refugee law, that there are differences, but that we need to be careful not to exaggerate those differences. That struck home to me because, again, of the time when I was reading the book. When I was in the middle of reading the book, the federal court decision on the Safe Third Country Agreement was just being kind of discussed in the media. The decision had just come out, and many of the folks who are in this Zoom call today were thinking about that decision, and thinking about how that was going to be likely appealed, and how arguments about that decision would play out in court. And one of the kind of key considerations in thinking about the Safe Third Country Agreement is this basic question of, is the United States safe for refugees? And kind of by implication, is the United States less safe for refugees than Canada is? And as I was reading your book, I was thinking about public positions that I had taken on that in my advocacy efforts to try to push back, both in kind of legal venues, but also in public debates against the Safe Third Country Agreement, and some of the discomforts that I had in those advocacy efforts. A real concern that by focusing my advocacy efforts on trying to make arguments about, look at how bad things are for refugees in the United States right now, and Canada should not be sending people who come to the border and ask for refugee protection. We just should not be sending them back to the United States because it's just not safe. And here's a litany of examples of ways that the United States is violating the rights of refugees. There was always this voice in my head that was saying, well, come on, like, look at the Canadian practices in this area. They're not so great either. then when I read the decision, I was struck that Justice MacDonald focused in the decision on an area of law where I actually see Canadian practice and US practice to be quite similar, and that's in immigration detention. Obviously, in the Trump administration, there was a greater use of immigration detention, and there are problems related to conditions of detention. But on immigration detention, Canada is an outlier in terms of some of the more serious problems with our regime, including, for example, the lack of an upper limit on the length of detention, mixing of people who are in immigration detention with people who are serving criminal law sentences. So it was striking to me that the court reached for that example without really querying Canadian practice in this area. So the second kind of lesson that I took away from your book is that folks like me, and I see a number of others on the Zoom call today, who have been involved in trying to push back against the Safe Third Country Agreement. I think we need to ask ourselves about that phenomenon of kind of just trying to present the U.S. as worse than Canada for kind of advocacy reasons, whether we actually believe that, whether in doing that we're kind of glossing over problems with the existing Canadian practice. And so I wondered about that as I was reading. Where I landed when I was thinking about that last question was that at the end of the day, I think I can live with the advocacy that I've done over the past years, despite acknowledging that in some ways I may have exaggerated the differences between Canada and the United States in this area. And the reason I can live with it is actually tied to another area where I think there is increasing kind of convergence in the Canadian and US context. And that's the area of kind of rhetoric around illegal, quote unquote, immigration. And so if I look back to most of the period that you've been looking at, and I think about when you had political actors who were opposed to either opposed to immigration in general or wanting to have kind of tougher border control policies, when political actors attacked refugees, they tended to do so using the language of kind of fraudulent claimants, right? They tended to say the reason we need tough border control measures, the reason we need a designated country of origin regime, the reason we need the reason we should not be providing healthcare to refugee claimants is because there are too many, quote unquote, non-genuine refugees who are abusing the system coming to Canada, using refugee law as a way of circumventing Canadian border control practices. And so it kind of sets up the deserving versus, non-deserving refugee. Deserving refugee is always somewhere else, not here. So that was for much of the time that you were looking at. But I think there's been a shift in recent years on this, and the shift is that because of the Safe Third Country Agreement, which is itself is as you show in the book, would not have happened without September 11th. Canada was pushing for a Safe Third Country Agreement for years and years and years. The US saw had no interest in entering into such an agreement. And so it was really September 11th that Canada leveraged to get that agreement. Because of the existence of that agreement, combined with the kind of Trump years generating folks wanting to come to Canada to make refugee claims rather than staying in the United States, the direct result of that was an increase in the number of irregular border crossers, because if you came to a regular port of entry, said you wanted to make a refugee claim, you would be sent back to the United States. But if you crossed the border irregularly, you'd be allowed into Canada, and you could make your refugee claim. The direct result of that was an dramatic increase in the use of rhetoric by opponents to immigration, saying, "Look, I'm not racist. I'm not opposed to immigration generally. You just have to immigrate to Canada the right way. You have to join the queue and wait in line and wait your turn, and not to engage in illegal, quote unquote, border crossings." I'm really concerned that the Safe Third Country Agreement has resulted in that kind of language playing an increased role in Canadian politics, because that kind of language has been seized on in the United States for years and years and years by opponents opponents of immigration. And it has had kind of devastating consequences on the political rhetoric in the United States and on policy in the United States. And so at the end of the day, the book made me think carefully about whether I was exaggerating some of the differences between Canada and the United States. Maybe, but I think it was the right thing to do in this context. So, Obi, thank you so much for your book. And unless you've got anything that you'd like to say now, we can open things up to discussion.
Just 2 minutes. I won't say, of course, as you can imagine, I have tons to say, but I'll just say two things very quickly. But first of all, thank you so much, Sean, for engaging so closely and brilliantly as usual with it. I agree with everything you said. I land exactly where you land. In the end of the day, I do agree with both this decision, federal court decision, and the earlier federal court decision as well, which was, as you know, before Trump, right? And I see. So I would say, to the great Sherry Aiken, the great Geraldine Sadoway, keep doing what you've been doing. We're proud of you. I agree with you completely. I still say it's different. It's just not as, say kind of the luxury of a scholar, right? I talked about this at a presentation 2 weeks ago. Scholars have to kind of do these nuanced little granular things, right? But when you advocate, you don't have that luxury in a sense, right? Because sometimes you don't want to provide their ammunition to the other side. Let them go work on it. It's interesting what you said about the Georgian detention. Although Jerry, I saw in the chat, did say that maybe it was more the unaccompanied minor thing as well. Maybe that was part of it, like the way they detain. Not that doesn't happen here at all, but again, comes back to, I guess, the scale can loom large because of the scale of what happens in the US, right? So I don't know to what extent that affects, the visuals are important, if you know what I mean, the CNN effect, Al Jazeera effect, whatever, right? Of scale, right? So maybe that's what is at play. But I'll just keep it there so that we'll have time for Q&A for now. Thank you.
Okay, so the way that we're going to do the Q&A is that if you'd like to ask Obi a question, you can use the raise hand function. If you're not sure how to use the raise hand function, it depends a little bit about what version of Zoom you're using. There should be a reactions button. You can click on that and raise your hand. Alternatively, if you can't make it work, you can send me a chat and I'll get you on the list. So let's start with Sherry.
Thank you. So Obi, I love this book, as I've told you before, and I've assigned it as mandatory reading to my students. I just think it's such an important contribution. And I actually just wanted to offer a comment, if I may, and then maybe one question. But the comment really is just to reinforce the importance of understanding the continuities. Indeed, one of the very first quote unquote scholarly papers I ever wrote in my life was called From Slavery to Expulsion. And it really was about the continuities in immigration law from post-Confederation Canada until today, how not much has changed at all. In terms of the security issues, which are so central in your book, one reflection that I have is really picking up on your comment about administrative law, and my feeling that administrative law is the enemy of human rights. My feeling that I'm always an outlier when I gather with other administrative law scholars who embrace the scholarship of deference and the principle of deference. And I just see it as so deeply troubling in this area. And in relation to security issues and refugees, probably the thing that happened prior to 9/11 that was really terrible in Canada was the evisceration of the role of the Security Intelligence Review Committee, which had actual authority in relation to inadmissibility concerning permanent residents before the current version of Canada's IRPA was taken away with the new immigration law, which of course was in its current incarnation before 9/11. And basically has meant that that's where refugees get caught up, right? They now get caught up in a system where there's actually no expert review of their circumstances. The people who are in charge of adjudicating inadmissibility at the Immigration and Refugee Board are not experts in this area, unlike the people who are assigned to the Refugee Protection Division, who are at least improved appointments today. The people who end up deciding what ends up happening to refugees before they actually get their legal status are not experts in security, are not experts in human rights, are not frankly experts in anything. And then it's impossible to have those decisions overturned in court. You mentioned the CRS case. I mean, I just want to add a footnote because it's not necessarily widely known that Mr. CRS is still battling removal in Canada. That his case went back to the Immigration and Refugee Board for new allegations of inadmissibility based on old facts that based from the 1990s. And the federal court upheld that finding because of deference and the impossibility of overturning decisions that turn on facts. So it's an incredibly frustrating area of the law. I actually was a very happy refugee lawyer until I got involved in this area of work, and I just threw in the towel after a few years because it was so frustrating. So here's my question after that long prelude. Is there anywhere that you can think of in terms of a jurisdiction where these kinds of continuities are not quite so horrendous? In other words, where you can look at the indicia that you've identified in your book and say, this jurisdiction's doing better in terms of refugees and human rights more generally, because we certainly know it's not on this continent. And so I'd love to hear what you have to say about that. Thank you.
Thank you. Thank you. Can I answer, Sean? Can I answer right away? Oh, okay. Great. Thanks, Sharon. As everybody knows, she's one of the greatest refugee lawyers and activists in the country. Thanks for the work you do. I agree with you. I think this is a new quote: admin laws, enemy of human rights. I don't know if Sean agrees, but there's a sense in which it is. It offers this protection, right, for all sorts of decisions. That you can't do too much, and it becomes this circling back, and no matter what the courts, even if the courts say anything, they can just come back, and it reminds me of the Nigerian police. The practice of when the courts, as they often do, grant bail in criminal cases, then they let you walk a few meters, then they rearrest you on fresh allegations. They complied for a few meters. So it's very parallel, right? So which kind of tells you where I'm going with your actual question, right? Which is, I don't think so, right? Like, I'm partly putting on my UN Special Rapporteur hat here because I've done 3 sort of, I guess, globalist reports on migration and solidarity, and it's depressing everywhere you go. These kinds of techniques and technologies. So think about the Mediterranean, right, and all the drownings and the duty to rescue and things like that. So what the sort of the states that are the southern European states tend to do, mostly Italy, because of positioning, and Greece, because of their location. What they do when they, for example, arrest those who provide succor, who rescue people who are drowning, activists, who get boats and all that, because they know that the law, even Italian law, doesn't support what they're doing. The reason they keep arresting them is not because the courts keep acquitting them, but the cost of defending yourself, both mental and financial and all that, over that time is the deterrent. So administrative people understand this a lot, and that's why they keep doing it, and they're happy to keep losing in the courts, because it takes a lot. It levies a lot of cost on the activists when they're arrested and detained and hauled through the courts and all that. The state hardly ever wins those cases, even in the Italian courts, but they keep, doing this, coming back and doing the same thing. So it's a bit depressing all around on this score. I can't, honestly, I wanted to think about it, but I can't quite think of any place where, not even sort of Sweden or Norway or places like that you would think, right? It's not much better when I've looked at them closely. It's unfortunately, yeah. But thanks so much for the question, and thanks for the point about the Security Intelligence Committee. I think it's something that I didn't quite pay a lot of attention to in the book that I should have, actually. Thank you so much. Yeah.
Thank you.
Our next question is Usha.
Thank you, Obi. So I was thinking about, can you hear me?
I can hear you, sir. Yeah.
Great. So thanks, Obi. So I was thinking about how useful this is, your contribution is from the point of view of the asylum seeker, as well as the international refugee law scholar in the South, which is the position that I'm in. So I've been in Egypt for the last 10 years, as you know, and now I'm based in Jordan. So I was reading it not from the North American point of view, and it is incredibly useful. I guess the most straightforward way that it's useful is because of the third state, the safe third state issue. So the asylum seeker does need to know these differences in negotiating this process. But I was also thinking from the point of view of the scholar, it's useful just in terms of those continuities are quite helpful in just saying that these agreements are just so unhelpful wherever they exist, these safe third state agreements, because the asylum seeker should be able to choose, where they apply. And that's what I was thinking reading this, because it's not straightforward. It depends on the person, it depends on the circumstance, the time, all of that. And that's why these agreements, at least in my mind, are awful. And we shouldn't have them. And even from a very sort of doctrinal point of view, there doesn't seem to be much basis for allowing safe third state agreements. So it's not so much, I don't have a question. I just wanted to say I found it really useful for that reason.
Thank you. If Usha says my book is useful, then certainly it's useful. Thank you, Usha. She's a great scholar, especially of refugee law from the Global South perspective. So she's a great successor to Chimney.
Our next question is Nergis.
Hi, Obi. It's great seeing you. And
hi, Nergis. How are you?
I'm good, thank you. I didn't have a chance to get the book. I ordered it, but I think it's in my office sitting there, so I might order it again and we'll see what happens. So my question kind of tailgates from Sherry's question.
Okay.
And I want to hear your opinion about the not so much grassroots, but local, municipal, and state level reactions to post 9/11 policies, especially in the Trump era, in terms of negating the federal orders. And and then that's the other aspect of admin law, right? It's not just the courts and the deference principle, but the tensions and the clashes between different branches or levels of government, as well as the citizenry pushing for accountability in general. So I don't think it's that hopeless, but that might be just me being the you know, the pessimism of the mind and the optimism of the heart business. So I'm wondering, yeah, is there anything similar you see in the Canadian context? Also, the whole development about the Queen's Counselor intervening now with the detention cases, like the arch of change that came as a result of the pressure from the bottom.
No, that's a good question, actually. One of the sort of the amusing things that I always kind of laugh privately in my study. You guys don't think, you know, I'm having a crisis laughing by myself in my study, but is when I'm doing my UN reports, there always has to be a section of best practices. And I'm sure you guys can understand laugh at that. I have to do it, especially on immigration. And that's the segue to sort of your concern, because I have actually mapped a lot of those best practices from the cities, right? I've actually said more cities should do it, essentially. More cities should do, I think it was Winnipeg, I'm not sure now, the city that said, listen, we're going to give identification, driver's licenses and things like that to everyone. We don't care what your status in the country is. I'm not sure if it's Winnipeg again, but I mapped. But many cities doing things like this, not just
sanctuary cities, right? So
yeah, sanctuary cities, all kinds of things, saying we're not going to cooperate. Our police is not going to, you know, do a stop and search and take, you know, hand over the irregular to Trump's ICE. ICE is the department that, you know, the arrest goes around prowling and around the, you know, these places to arrest and deport people, right? So there's all kinds of praxis of resistance by not just cities, municipalities, but of course by activists, right? So one of my reports was actually on the criminalizational suppression of solidarity, and how they keep winning these cases. Kind of segue to my response to Shai. They keep winning and they keep coming back and doing it. And making solidifying, not making the law, but solidifying through almost the pain they suffer, the fact that this is the law that they allowed in the US. They've won, right? So I was in the panel at the last American side of international law with Gregory Kuykendall, who defended this scientist who just leaves water in the Arizona desert, right, for people who would otherwise die of thirst. Like there are lots of people who die of thirst, right? So, and he was arrested and charged. And then, you know, he took some home and gave them food and whatever. And so these lawyers, you know, they use all kinds of, you know, loopholes in the law to defend them successfully. There's tons of examples in Europe. So, for example, the French Constitutional Court has now been led by a farmer and his lawyer. I was again on a panel in Geneva with his lawyer. His name escapes me right now. And there's many other cases, but who said, listen, if any so-called irregular migrant or refugee comes, asylum seeker comes on my property, I am going to feed them, house them, you know, and protect them. And I'm doing under the principle of fraternité, which, you know, which is a French constitutional principle, which embodies, so the Constitutional Court has ruled, the principle of solidarity. So I actually have a whole UN report on it. So I guess maybe I was kind of overtaken by all the frustrations when I responded to Shai, when I said, you know, it's terrible. It is still terrible, but there are rays of hope here and there, right? You know, Yeah. So, but thank you for pushing me, or rather, steering me in the more positive direction. Yeah.
Sujit is next.
Hi, Obi.
Oh, there he is. Hi, Suj.
It's really lovely to see you.
Same here.
In a while, and it's lovely to hear all of the voices of the TWAIL folks. So I guess my question to you, and I must confess that I haven't started the book yet, but my question to you kind of comes at this, I guess the comparison that you're doing from the view of both TWAIL and race.
Okay.
And so I was just wondering, and this is something that I've been struggling with quite a bit. And it maybe comes back to Professor Aiken's point as well. But, I find that refugee law in Canada and, I assume in the US is fairly white, right? It has a fairly white supremacist structure to it. The lawyering that happens is fairly driven by white supremacy. And so, and when you think about the board, it's also driven by white supremacy in terms of who's appointed, who's, the type of politics that they have. And so I guess my question to you is, what is the role of race in the excavation that you've done in terms of the case law? And is there, I have a hypothesis around race, but, I wanted to kind of get your sense of what you found in terms of how race played out. And here I'm thinking of Suresh, right? And Suresh is someone that whose story I know quite well. Pushpanathan, there's a bunch of cases that we can talk about. And, I think, if you think about the Suresh decision or the Pushpanathan decision or even the Kandasamy decision, the Supreme Court is very clear in setting out only 3 sentences about their racial identity. And it's in the first paragraph, and that's it. They move on, right? And I assume it's the same thing in the US. So I wonder if you had some thoughts or some reflections on it. Thank you, Obi.
Thank you so much, Suj, and thanks for always asking the hard questions. You haven't changed since you got your PhD. I'm just joking. Anyway, great questions. Of course, Suj, it's impossible, just like it's impossible to evacuate politics from refugee law, right? So draw that line. You can't evacuate race from it. In fact, it's almost the quintessential race question, right? The order, right? Significantly along a racial kind of axis is trying to, as one of my friends who's an accountant put it once, saying, oh, can you shift a little in a kind of Nigerian pidgin? Shift, make I sit with you, right? That's Nigerian pidgin. Shift so that I sit on the same, like this seat I'm sitting now. That's how a lot of people perceive it, right? I thought that was very, he's an accountant, he's not really a lawyer. That's kind of, so that, and then is kind of this person that looks different, that it wants to sit on that same seat, not even a bench, but a seat with you, right? So so it's been like that. So as you know, or maybe you don't know, but I spent 2 weeks on that in my immigration class, right? So I'm not, again, with this whole thing that history doesn't ever rupture, right? So I start from the Chinese, the Indian, the Maru, you can talk, or my favorite, which is that act that says that Canada excluded from Canada those unsuited to the climb. So I often joke with my class, and you get them laughing every time. And I'm like, that was targeted at me. People who are suited to the climate of Canada. It was the actual act, right? That was passed into law in this country. So I often tell them, I don't know. I kind of tell them facetiously, I don't know if he was racial. Of course, he was around freed slaves who were coming here. But I said, I just know that I don't like the cold. So maybe I'm unsuited to the climate. Maybe I shouldn't be here. And it gets them to understand the racialization of the law, even if I spend the next 10 weeks grappling with the and all the exceptions in whatever. And I always invite them constantly, bring that back to that. So that's just sort of the I guess the baseline, right? I think that part of the public reaction that then drives a lot of the politics, right, is that, right? As think about what they did to those minors, separation of minors in the States. Think about, would they do this to sort of Swedish kids? If they were all Swedish and they were at the border. I find that hard to believe. It's like that character said yesterday, he wasn't worried about Trump supporters invading the Capitol, but he would have been really worried if it was Black Lives Matter. He actually said it, Senator Johnson, yesterday. He actually said it. People are surprised because he said it and just didn't think it, right? So you can extrapolate. These are the people that make the law. What do you think, right? But of course, there's always currents and countercurrents. That's not the only current, and it gets complicated around sexual orientation, around gender, around all the economic. Nigerian billionaires, I tell you, have no difficulty. Mostly, they do sometimes accessing everywhere, right, in their private jets. Or should I say, have less difficulty moving around the world than even the Nigerian middle class, who are not necessarily poor or whatever, right? So you can kind of do that class analysis as well. It gets complicated, right? But that doesn't mean that the Nigerian billionaire cannot be racialized. They have, even in South Africa, one was racialized that I went to school with. So it tells you. So I agree with you. There's a lot of that goes into. But again, like I urge in the book, we then have to be sure to specify it, right? Like to look closely, right? I think you know that one of my next projects, whenever anyone says colonialism, I said, no, wait. Can we go drill deep and specify precisely how does it work today? You know what I mean? How exactly? And maybe if we looked at it deeply, it may not be colonialist. Maybe it's actually a new, worse form of domination. You get that point I'm making, like, but liberating people from saying everything is colonialism and saying, well, there are actually continuities with colonialism, but maybe we need to call it hyper-colonialism. I don't know, something else, so that's kind of my approach when I'm sort of maybe an activist. It's slightly different, but in my sort of scholarly work, that's my tack. So thanks, Sij. Yeah.
And our next question is Chika.
Thank you, Sean. Thank you, Obi, and congratulations on this book. I just want to say, first of all, that I haven't read it, but thank God that I logged in and I listened to it, and I'm going to come slightly from a practitioner point of view, and not really a question, but just to get your perspective and your view, and listening to you on the comparison you've made on the Canadian and US refugee law. It begins to make me to wonder, especially coming from the point of view of someone that's working in the field, engaging in humanitarian assistance. If there is a direct correlation between what you're seeing in the data you have, but in the level of investment that maybe aid investment that US and Canada are making in terms of humanitarian assistance in the South, or especially in conflict zone, but also more specifically investment in support of refugee camps and IDP camps in the global South. If there is some sort of a correlation, on what's your point of view on that? Thank you very much.
That's a very good question, from a practitioner that has a PhD. So that thinks conceptual. I think that I haven't sort of mapped that data. I mean, the second kind of data, I have my own data, but just actually looking at the actual levels of investment. Anecdotally, it seems to me that the US spends more. I don't know, I can be corrected, than Canada, even pound for pound, even per capita, I think. Maybe you can correct me if I'm wrong on that. there is that sense that the US invests more on the African continent, even though some would question why, right? Like, why are they investing more? Is it, because they grab more or whatever? Canada does a lot of mining too. But I foreign policy wise on the continent, I would suspect that I would see similar degrees of both separation and, if you like, similarity and difference in the foreign policy of both the US or Canada on the African continent, right? The rhetoric is similar for the most part, but in terms of action, praxis, I would see both a certain level of similarity and a certain level of difference, right? That, again, I'm just speaking because anecdotally here, I haven't really given great thought to it, but I think that there's something there to your comment, and I promise to think more about it. Thank you, Chika. Thank you so much. Yeah.
Does anyone else have any questions for Obi?
Sean, can I just try one thing? What's your next project, man? Like, you kind of evaded that.
My next project. You mean the next 17-year one or the next?
Give us a few answers.
Right now, I've just finished. I'm toward the end. Let me not be too ambitious. I just finished. I'm toward the end of a project where myself and my postdoc and some of my graduate students, PhD students, we did a multi-year study where we kind of turned the camera on activists and not one international court, West Africa's International Human Rights Court, right? So the usual methodology is to say, what are these courts doing for activists or doing for ordinary people, right? The subaltern, right? And so the camera is on the court. So what we did was to turn the camera back to the user and say, how does the user play around with the court? How do they use them as a resource in their hands, right? So I'll give you one tiny example again from the police. Seems I'm fascinated with the police. So they like to detain people for no reason in Nigeria. So human rights lawyers have their hands full. Some of whom are here, one of them is my doctoral students. They have their hands full, so you have to constantly think of ways to, if you like, leverage pressure on them, right? So one thing they've done a few times is to say, actually, if I go to the court now, even though there's no requirement that you exhaust domestic remedies for one reason or the other, this application will be thrown out. But I'm actually better off going straight to the ECOWAS court rather than a domestic court in some cases, and publicizing. The day I arrive, the cameras would follow me, the national, national TV. The local police office commander that is detaining doesn't want to be on national TV because all of a sudden, the Inspector General of Police is calling from the capital, because we have one national police, which is another discussion, right? And saying, why are you embarrassing me? The president, sometimes the vice president comments. So that's a way, so traditionally, the idea would be that the lawyer would only go to the court when they think they're going to win a case, But when you turn the camera around at how these creative activists actually deploy this court, you begin to see they're not interested in state compliance, for instance, right? Because that's what international lawyers tend to map. To what extent, no, it's not about state compliance with the court. It's something else that I've called correspondence. That's what they want. They want correspondence with the international norm and the behavior of the police commander, right? In fact, they end up losing but before they lose the International Regional Court case, the commander is under enough pressure that they release the person, so they get what they want, right? So we're kind of mapping these kinds of creative uses from the user focused perspective, not the court focused perspective. So that's one project that we're doing.
Thank you.
Thank you.
And we have one last question from Ope.
A proud Osgoode grad. Are you there? Oh. What's going on? Maybe she doesn't know she's on.
Can you hear me?
Yes, I can hear you now. Yeah.
Okay, I wasn't sure to use my phone or the computer because it was acting up. So, but can you hear me?
Yes, we can.
Okay, so no, because I was gonna, when Najis was asking you what your next, what your project was, I was gonna offer something that I think is interesting and just hoping that maybe you can take it off from there. So just before COVID in 2019, I did a pilot project with the Houston Immigration Court. I had about 45 law students, and we did a court watch project. I was consulting for a nonprofit. And what we did was, like you said, we turned the lens on the Houston Immigration Court and observed them for a period of 5 weeks. And I don't know if you, because I haven't read the book yet, but I don't know if we have, looked at this from a due process angle, which is what I did. And to see, and I do understand we can look at it from a third world perspective of race and all that, but I actually looked through the lens of even the mainstream, which was due process, and how I looked at translation, I looked at the children, I didn't even look at the merits, just even the preliminary observation. And what I found, and based on the recommendation, was even within the immigration, and this is the U.S., for those who are now in the U.S., the so many due process issues. Obviously, even the immigration court in the U.S. itself is not a court. It's not an Article 3 court, to start off. I don't know. So I'm not sure if this is something that you can think about in your work as you go on to even look at the immigration process and the procedures and the implementation from a due process angle and do a critique of that. Because, when we come from the third world perspective, we are thinking, oh, yes, they're coming with their baggage. But can you even look at it through what the mainstream standards are? And you see that it falls short. And this is not post-911. The U.S. immigration system is fit from the beginning, where we look at the INA, even the language, we are considering changing the language of our immigrants, of aliens, So those are things that even if you look at it from, even if you don't want to take a total perspective, look at it from the mainstream perspective. There are many things to untangle and to look at and critique even from that angle. So if you have a project, oh yes, that's
all I'm going to say is that I did the book over 17 years. So probably when you were my doctoral student, you snuck into my office and you saw the things I left in the box. I had to abandon precisely that chapter in order to actually give the book a chance of ever getting published. So that was one of the chapters I didn't get to. I had a chapter at collected materials. I was meant to write it on just looking at the due process in reality. Was there any alteration, post 9/11, how was it affected? But I just couldn't get to it. And that's why I did only, I think, 3 or 4 or 5 discrete areas. So I didn't get to that. So who knows? Maybe a paper. I don't want another 17. I don't even think I have 17 more years before retirement, but we'll see. We'll see. But thanks, Obe. Thanks for the work that you do there in the immigration courts in Houston. Thanks.
Great. Okay, well, we're at the end of our time together here this afternoon. So all that's left is for me to thank you Obi, for a wonderful presentation and a great discussion, and again, for a great book that I recommend to everyone. I'm going to put a link again in the chat. So if you don't yet have the book, I'd encourage you to buy it. Thanks, Obi. Thanks, everyone, for being here today.
Thank you so much. I really appreciate it. Thank you. I really appreciate it. Thanks, Sean. Thanks, Michelle. Thanks to everyone who came. Yeah, I appreciate it.